Thank you. We want to bring in attorney Mark Lindquist now. Mark, this was the first case where a conviction was issued since this law, the state requirement was removed requiring malice to be proven by prosecutors. So can you tell us what this means for the future of these types of cases in our state?
Prior to I-940, it was almost impossible to bring a murder charge against an officer because proving malice is such a high hurdle. Post I-940, we've only seen two of these cases go to juries. The first one was Manny Ellis, which resulted in an acquittal. This, of course, resulted in a conviction, which tells us an officer can be convicted if the evidence is there.
Let's talk about the Manny Ellis case, because in that case, a different case in that the defense brought forward the case. There was a lot of testimony from those officers. Much different in this case. Did that make an impact at all in this trial?
Oh, I think so, Steve, and you're right, much different. In Manny Ellis, the defense attorneys put on a full-blown defense. They called witnesses, they called experts, and they put on two of the three officers. And I think the only reason they got away without putting on the third officer was because the first two officers told their story.
The defense has already said we are going to appeal this case. What would be the grounds for appeal?
You know, the defense always appeals. I didn't see anything in this case that said to me, big appeal issue.
Okay.
Okay, and then sentencing, that's already scheduled. What's that process going to look like for him?
The judge is likely to find that even though the defendant was convicted of two charges, it's same criminal conduct. So looking at a minimum of 20 years, maybe more, up to the judge.
Is there anything else that stood out for you in this case? And, you know, it was definitely a high-profile case, a lot of people watching, and some people surprised today in the courtroom with this conviction.
What surprised me was the defense choosing not to put on a case. You know, one of the fundamentals of our justice system is the defendant does not need to testify. The defense does not need to put on a case. That said, I think the public and jurors have different expectations of officers than a generic criminal defendant. Officers are public servants, and if they use deadly force, the public wants to know why. The best person to explain why is the officer. That's what they did in the Manny Ellis case, and they were acquitted, and that's not what happened here, and there was a conviction. I don't think that's coincidence.
Yeah, that choice was pretty surprising. Would that, in your experience, have been a joint decision with the officer to not testify and not put any defense on?
Yeah, absolutely. You know, they are going to rehearse that officer, you know, much like the debate prep that's going on right now for the presidents.
Yeah.
There would have been a rehearsal for the officer, and maybe it didn't go well. We don't know.
Okay. Mark Lindquist, thank you so much for being here with your analysis. We want to point out that we're going to cover this story throughout the day here on King 5. Again, this breaking news that came in today. You can text the word app to 206-448-4545. We'll send you a link to download our app, and we will have the latest developments in this trial there.